Good morning or afternoon. We are beginning the final lecture of the semester. This is going to be on employment law and discrimination and is a very critically important lecture, as I estimate that 20 to 25% of the final exam will come from employment law, things we have covered in class plus this lecture. So make sure that you study this material. For today's lecture, I'm going to recommend that you first of all, review Chapter 17, the PowerPoint, particularly Slide 6, and the Fair Labor Standards Act handout. The FLSA handout contains very specific information on the wage and hour laws that apply for Fair Labor Standards Act. In particular, you want to make sure that you pay particular attention to some of the exceptions. The overtime laws in general require that overtime be paid at time and a half for hours worked over 40 hours a week in a work week. That's not over 8 hours a day, that's over 40 hours in a work week. That's also not over 40 hours Monday through Friday. It just depends on when the work week begins and when it ends. You could actually work more than 40 hours on a Monday through Friday and yet not qualify for overtime depending upon when the work week occurs. A couple things that we mentioned in class that I want to go ahead and review with you is that under the Fair Labor Standards Act, you also have exempt employees and non-exempt employees. I gave you a couple of examples of companies trying to misclassify employees as exempt employees or salaried managerial type employees with supervisory powers. And the example I gave was the I think Dollar General store, where they had a lot of assistant managers who were not truly managerial type people with supervisory powers. A court held that they were required to pay them overtime because they truly were not exempt and should have been, under the Fair Labor Standards Act, qualified for overtime. So be sure and review the Fair Labor Standards Act handout. A lot of employees also are forced to work off the clock or wait time. The Hooters case that is in arbitration right now that I mentioned to you involves both of those issues, where the waitresses are required to wait until the manager settles up with them and are not permitted to leave, and that may be 5 or 10 minutes, or it may be an hour, it may be 2 hours. It just depends. In addition, some of the times they require them to actually perform work off the clock. All of those are violations of the Fair Labor Standards Act. Okay, tonight we're going to cover Chapter 18, and in particular I'm going to go ahead and give you the slides we're going to cover, slides 1 through 3, 5 through 8, 10 through 12, 14 through 20, and slide 22 and 25. And that's all we're going to cover today. We're going to talk about mainly the Title VII, Age Discrimination, and the Americans with Disabilities Act. Title VII being the most critical of all of the federal anti-discrimination laws. It prohibits discrimination in employment on the basis of race, sex, color, religion, and national origin. In other words, a person has to fall within a protected class of people that includes race, sex, color, religion, or national origin. If they are in that protected class, one of those protected classes, then the federal laws give them certain rights and protections. Title VII prohibits discrimination on the basis of all the things that we've talked about so far. And any policy that discriminates are illegal unless they have what is called a substantial, demonstrable relationship to realistic qualifications for the job. And that's a lot of words that basically means this. If you can show that hiring someone and discriminating on the basis of a lot of these different type of classes has some sort of realistic qualification for the job, then you are permitted to discriminate. There is one exception for that, and that is race. I want to give you a little better explanation of what I'm talking about with an example. Some of you may remember that years ago, the Equal Employment Opportunity Commission, EEOC, which does the investigation for these matters, was trying to sue Hooters on the basis of not hiring males for their Hooters girls position, basically the waitress positions. And Hooters, of course, only hired females for that position. Well, Hooters maintained that the Hooters girls were not waitresses. Instead, they were entertainers or actresses. And in order to fit the role that they were playing, they needed to be a female. And the EEOC eventually bought that and accepted that as a bona fide, substantial relationship to a realistic qualification for the job. So Hooters can, in fact, discriminate on the basis of sex by hiring only females to be Hooters girls servers for their restaurants. Race can never be one of these relationships. So if, for example, you had another type of restaurant and you wanted to hire only white male or female servers, or only black male or female servers, any policy that would discriminate against the other race would be an illegal policy, because you cannot qualify that as a substantial, demonstrable relationship to a realistic qualification for the job. Discrimination on the basis of religion requires that employers reasonably accommodate the sincerely held religious practices of employees. There is an exception to that, or maybe I shouldn't say an exception, but actually it's part of the law, and that is that if reasonably accommodating would be an undue hardship to the employer's business, then they are no longer required to do that. And what does that mean? Well, it means this. Let's say, for example, that an employee works for a company that provides food and beverages and souvenirs for football games. There are game day concessions and souvenirs. And the company does 95% of its business on football Saturday in the South. If that's the case, and the company needs 30 employees to work on Saturday, and they need 2 employees or none to work Monday through Friday and Sunday, then hiring someone who says that they need as a day off Saturday because it is their Sabbath and a holy day for them, and they are not prohibited, and they are prohibited from working on that day, that would cause an undue hardship to the employer's business to not have that employee work, and they would not be required to reasonably accommodate that religious practice of the employee. Now let's switch the example and let's pick on Walmart. That's open 7 days a week, and Walmart hires an employee, and they work 5 days a week, and the employee says, one of my days off needs to be on Sunday because that is my day of worship, and I am prohibited from working on that day. Well, since there are 6 other days that the employer can choose 5 for the employee to work, that would not create an undue hardship to Walmart to honor that request. And if that's the case, then they would be required to reasonably accommodate that religious practice. Discrimination based on gender is exactly as I mentioned in the Hooters example. If you can prove that gender is essential to the job, and in the Hooters case they did, then they can advertise for the job as male or female. There are 2 different types of discrimination in sex discrimination and sexual harassment. Let's discuss sexual harassment first. 2 different types of sexual harassment are called quid pro quo and hostile work environment. Quid pro quo harassment involves a demand by supervisors for certain sexual favors from a subordinate for some tangible benefit or lack of a detriment. It kind of works both ways in the workplace. And in English, and in an example, this means this. A boss goes to an employee working under the boss and says, I need you to go out with me, have sex with me, whatever. If you don't, I am going to fire you. Or on the positive side, if you sleep with me, then I'll make sure you get that job promotion that you've been wanting. That's an example of quid pro quo type of discrimination. Now, employers are responsible for this kind of thing if and only if the employee themselves are also responsible. It's the same thing that we discussed in the respondeat superior type of liability earlier this semester. If a company is only responsible if the employee is responsible as well. So a company has a truck driver and they negligently drive their truck and hit someone and injure them. Well, not only is the employee liable, but the company is also liable because the employee is liable, as long as it's within the course and scope of their employment. Well, the same thing here. If you have a supervisor who is liable for sexually harassing someone, then the company might be liable too. And I keep saying might be liable because there's no guarantee necessarily that they're liable. They're only liable under certain conditions. And let me back up. We're probably going to cover this later. I can't recall if the subsequent slide does, but I'm going to go ahead and mention it. What do you have to do to show that an employer is liable for the actions of the employee in a sexual harassment area? Generally, it's this. You have to give the employer an opportunity notice and an opportunity to correct the offensive behavior, and they must fail to do so.